Hi, I'm Jessica Matthews, a solicitor here at Michael Lynch Family Lawyers. Thank you for coming along to this webinar about family law essentials. Just a little bit about who we are as a firm. So Michael Lynch Family Lawyers have been established for over 25 years. We're a specialist family law firm, which means we only practice family law. That is our specialty. We have 11 lawyers, 5 of whom are family law accredited specialists, so that is the above and beyond accreditation, and we take on private clientele. We do offer a fixed fee initial consultation, so if you're looking for that initial advice or just to come in and have your questions answered, that is an option. Just a little overview of what today's webinar is going to touch on. So as the points say, we're going to talk about family law terms and processes, primarily children and parenting matters. I'll also talk about children's wishes, touch on domestic violence, and also property settlements, which ties into the jurisdiction and time limitation issues. Just wanted to remind you that this is only general information and not at all specific to your circumstances. If you are tuning in because you're going through a separation, if you are looking for specific family law advice, we strongly recommend that you contact a firm and or book an initial consultation with us as stated. So just wanted to also quickly flag that although you're most welcome to ask questions, they're not something I can address during the webinar. So if you'd like to ask a question, please feel free to send an email afterwards and I can get back to you. So just getting started, I guess just a general outline of family law and, you know, the general points. So it's governed by the Family Law Act. So that covers all matters in relation to children, parenting and property, which is activated by separation. And obviously, being legislation, it is subject to change quite frequently. The Family Law Act governs all states except for Western Australia, who do actually have their own legislation in relation to most things. So generally most of Australia, but if you are in Western Australia, we strongly advise you get law from a specialist family law firm in Western Australia. In relation to the court, the relevant court is the Federal Circuit and Family Court of Australia. So in September of last year, there was actually a merger. That is the new name of the court for the family law system. And there are 2 divisions within the court, Division 1 and Division 2, which deal with different complexities of matters. In terms of what the people in which like family law govern, obviously married couples, de facto couples, and also parents of children. So here are a few of the legal terms and processes that I'm going to touch on throughout the webinar over the next hour. Divorce, separation, de facto, a lot of these are common terms used. A lot of these are also specifically defined in the Family Law Act or may have specific definitions within the family law environment. So obviously, if that's the case throughout, I will let you know. But yeah, these are all the things that we're going to touch on throughout the webinar. So I just wanted to flag possible legal issues. In relation to the list here, I'm probably only going to discuss in detail 3, which are children, property settlements, and domestic violence. I will briefly spend a little bit of time on divorce now. Obviously, that's quite a common one. But if you need legal, obviously all of these are common family law issues, and if you need legal advice in relation to any of them, you could go speak to a family lawyer in relation to them. Spousal maintenance, paternity, change of name, and child support are all relevant. Child support specifically is actually governed by the Services Australia, but you can enter private child support agreements as well, in which case you would need family law advice. So just briefly on divorce before I move on. The main issues with divorce are that you need to be separated for 12 months prior to filing for divorce. When you do decide to file for divorce, you can do it either jointly or solely. So if you were to file jointly, so if you're amicable with your partner and you decide, yes, we both want a divorce, you can both file the application together and co-sign it. It's a lot easier in terms of being processed by the court. However, if you do file it solely without your ex-partner or ex-spouse signing the documents, you would need to personally serve the documents on them. So you would likely engage a process server. It needs to be served on them and they would sign an acknowledgement of service. Again, that is something we can help you with, or a lawyer if you need assistance. Alrighty, so mediation and FDR being family dispute resolution. I might spend a little bit of time on this one because it's a great place of where you start if you're going through a separation. The main thing I wanted to flag before I even hit any of these points is the family court during their merger last year introduced pre-action procedures, which are the steps the court requires you to take prior to filing with the court. So there's 5 primary pre-action procedures. In relation to financial matters, they are exchanging financial disclosure. So that's all documents relevant to your financial position, your bank statements, what assets you hold and things like that. There is an ongoing obligation to provide full and frank disclosure during the court process. The other things are to set out the issues in dispute. So that is in relation to whether it's parenting or property, what matters have been agreed upon, and then what remains contested. You'd also be required to make an offer for settlement and also set out what orders you would be seeking if your matter were to proceed to a final hearing. So the 5th and big one is to attempt dispute resolution. So there is a great focus in the family law environment on dispute resolution and that process. Obviously, it's the court's preference that any agreement reached between parties is one they've come to themselves. It's a lot easier to be complied with if it's something you've agreed to rather than being enforced on you by the court. So prior to filing with the court, it is encouraged and required that you attempt dispute resolution. So do parents have to? Yes. In relation to parents specifically, Section 60I certificates are required to file in parenting cases. So a Section 60I certificate is something you would obtain from a mediator once you've attempted mediation or dispute resolution. The 2 main ways you can get that is by actually attending mediation and not reaching an outcome. That is, both you and the other parent of your child went to mediation, you tried to work things out and you simply couldn't reach a resolution. Your mediator will sign a document that says, you know, both parties attended, they had a fair go and couldn't reach an outcome. The other way you can get a Section 60I certificate is to invite the other party to mediation. However, if they don't attend, your mediator will still give you a Section 60I certificate to say that you attempted mediation, the other party was not willing to engage with the process, and that would then allow you to commence proceedings. Obviously, as well as all the other pre-action procedures and things you need to do. In relation to the types of mediation you can attend, the primary one that is used in family law is shuttle mediations. Basically, what that looks like is your mediator will shuttle between you and the other party. So you would be in a room either on your own or with a legal representative. If you took a lawyer, your ex-spouse or partner would be in a different room with themselves or their lawyer, and obviously you can also have support people come to your mediation depending how helpful that would be for you. Obviously we don't recommend taking someone who's going to hinder your negotiations, but you'd be in separate rooms and the mediator would go talk to you, talk about matters, offers, and then take it to the other party. The positives with that is obviously if it's a high conflict situation or you feel that you may make concessions that you would not otherwise make, if you're in the presence of your ex-partner and would feel like you would make concessions being around them, you don't have to be in the same room as them. There's not that tense conflict of having to look at them across the table, for example. And obviously the mediator can reality check you or, you know, see how far you can go without them being around. So that is preferred, obviously, in high conflict cases such as family law. The other option is round table, where all of the parties are in the same room. So the mediator, both parties and their lawyers, if they have them, would all be in one room around a table. And that can be helpful I think if you don't have lawyers and you both want to get the information directly from the mediator at the same time, it can be more efficient. Obviously, it depends on how amicable you are and how comfortable you are being in the presence of your ex-partner. The other option is dual mediation, and that would be where, so dual mediator, where you both have a mediator each, and obviously a bit more costly, and they would then negotiate. Sorry, I'm definitely not doing these points in order. So legal representation or not. As I said, you can attend mediation with or without legal representation or with a lawyer. Obviously, that may, whether or not that's an option may depend on your finances, but there is great benefit to having a lawyer with you, if not only because of the preparation they'll do on your behalf, but also, you know, most lawyers have done mediation many times. They know how it goes. They know sometimes when you should and shouldn't make concessions, and how far you should go with that. It also helps having someone else in your room who isn't necessarily as emotionally invested in the outcome as you, but is willing, obviously, to support you and tell you what's within your rights. The best way to be prepared for mediation would definitely be to have a range of expectations. If you're attending mediation hoping for a single outcome, you are definitely more than likely going to be disappointed. You are going to get the most out of mediation if you have a best case scenario, worst case scenario, and, you know, settle somewhere in the middle. They say that a successful mediation is when both parties walk away with something they can live with, not something they're happy with. That would be wildly successful and rare, but something they can live with. And just wanted to also mention that mediation is confidential and without prejudice, so anything that you offer or say within the mediation wouldn't then be brought up in court. It's all kind of kept within the scope of the mediation, so you can make concessions that you may not be willing to stick to, I guess, outside of the mediation to progress things and move things along. There is an added benefit of the intensity of a mediation, being in one room and wanting to get everything done, you know, because it's quite motivating, and obviously there's the added bonus of having paid a professional mediator to help you both with that. Right. So moving on to children or parenting matters, just wanted to quickly highlight that there were two changes, or significant changes, as changes quite frequently to the Family Law Act. But in 2006 is when there was a big shift in relation to dispute resolution. So this is when the court first required parties to attend dispute resolution prior to filing with the court. It's a really big shift to kind of collaborative, dispute resolution based problem solving. And in 2012, there was changes in relation to family violence. So that was when the court kind of asked what they can do to best protect victims of family violence throughout the court process. Just in relation to background of terminology and children. So I know there's a lot of use of custody and access to children, probably custody primarily, but in terms of the law that actually hasn't been used since pre-1996. Post-1996, there was reference to a child's residence and what parent they had contact with. But the current position as it is now and has been since 2006 is who the child lives with and who the child spends time with. So they're the primary terminology, is who the child would live with and spend time with. In relation to children's principles, parenting principles, a child's best interests are paramount. So that is the court's primary consideration. They also consider that both parents should have a high level of meaningful involvement in the child's life, and that parents should try to agree. Obviously, as previously mentioned, something you agree to and something that you've come to kind of with your ex-partner or co-parent on your own is probably a lot easier to comply with than something a judge is enforcing upon you. There are two main issues in parenting matters. So parental responsibility and living arrangements. So I'll go on to talk about parental responsibility in the next couple of slides, and living arrangements kind of is a larger consideration, which I'll talk about when we talk about the best interests of the child. So in terms of parental responsibility, that refers to the care, welfare and development of a child. So in terms of major long-term issues, those are defined in Section 4 of the Family Law Act, and they refer to things, obviously major long-term issues, so your child's education, where they go to school, their religion, what religion they practice, if any, major health concerns and health issues, their name and their living arrangements so far as it affects that child's ability to spend time with the other parent. Obviously, if you're moving from one suburb to the next suburb over, no worries. But if you're looking at the child's living arrangement and moving hours away or into a different state, that is something that actually needs both parents' consent and input. In terms of day-to-day issues, that would be things like, you know, what your child eats and things like that. Ordinarily, there is a presumption of equal shared parental responsibility, and parties agree to that on major long-term issues, but the day-to-day issues is more in relation to who the child is in the care of, and they would have the primary parental responsibility in relation to day-to-day issues. So you don't have to text your ex-partner and confirm what your child's eating with them. That's not an issue. So just in relation to that presumption of equal shared parental responsibility, this is kind of an overview of what that looks like. So if the presumption exists, the court has to consider an equal time arrangement. So just kind of in the bottom of that slide, when considering that, they do consider the best interest of the child and whether or not that's reasonably practical. So I will talk about this in a little bit more detail, but in terms of an equal time arrangement, that's, you know, week on, week off, just having equal time with both parents. Obviously, that isn't the most practical outcome for every family situation, and that's why that's taken into consideration. So things such as, you know, the hours a parent works, where they live in relation to each other, or where they live in relation to the child's school, are all relevant as to whether or not an equal time arrangement would be reasonably practicable. If it's not, the next thing to consider is a substantial and significant time arrangement. So substantial and significant time refers to all aspects of a child's life. So obviously, if you think back 10 or so years ago, maybe longer, there was an arrangement or a common arrangement where one parent would have primary care of a child, and every second weekend or 2 days out of a fortnight, they would go spend time on a weekend with their other parent. So the court doesn't consider that to be substantial or significant time, simply because that other parent doesn't get to engage with all aspects of the child's life. So we're talking, you know, school pickup and drop off, homework, extracurricular activity, nighttime routine, and all of those things, holiday during term time. So substantial and significant time is touching base on all of those aspects of a child's life, and not just having the every second weekend fun time with one parent. In relation to the presumption of shared parental responsibility, obviously the exception to that is family violence. If there is family violence, the presumption does not exist, and that is because of the best interest of the child and it potentially needing to be sole parental responsibility rather than equal shared parental responsibility, which means one parent has sole parental responsibility in relation to the decision making, for the child. So it is possible to have sole parental responsibility in relation to some specific issues such as education or health, but if there is family violence, they will consider kind of all of those issues in relation to that. So I've mentioned quite a bit about best interests and what that means. So the primary considerations in considering what is in the best interest of a child, those on the screen. So the benefit to a child having a meaningful relationship with both parents, and also the need to protect the child from physical or psychological harm and from being exposed to abuse, neglect, or family violence. So of those two, the need to protect the child is actually paramount, and it will trump the benefit of a child having a meaningful relationship with both parents. So that means if one parent is potentially exposing the child to abuse, neglect, family violence, or physical or psychological harm, the need to protect the child is going to trump that parent having a relationship with the child. So when looking at best interests, those are the primary considerations, but there are also quite a few additional considerations because obviously there's a larger picture in relation to the best interest of a child. So moving on to those. There are quite a few. I'm just going to quickly touch on them, but the views expressed by the children, I'm going to talk about this in more depth shortly, but they are taken into consideration to an extent. The nature of a child's relationship with each parent and other persons, such as grandparents and relatives. It's also worth mentioning siblings. It's not the court's position that siblings should be separated. And obviously, if they're half siblings and things like that, it's important to promote their relationship with half siblings. So often if one parent has children of multiple relationships, they try and make their parenting arrangements line up so that those children get to spend time with each other as well. The extent each parent has taken to participate in decision making, spend time and communicate with the child. The likely effect of a change in circumstance for the child, including separation from a parent or relative, and also the practical difficulties, which I previously mentioned, of spending time and communicating with each other parent, and expense or difficulty of that time. So the court really values or puts emphasis on parents who promote the child having time with the other parent. If you're quite hindering of that relationship, it's not well regarded. And obviously the court considers who has been the primary caretaker and the relationship the child has with the parents when making any kind of future arrangements for the child's time. Further additional considerations, the parent's capacity to provide for the children's emotional and intellectual needs, the maturity, sex, lifestyle, background of the child and parents that may be relevant. If a child is Aboriginal or Torres Strait Islander, the right to enjoy that culture and the impact of any proposed parenting order on that right. Any family violence, including consideration of family violence orders, the circumstances of the order, the evidence admitted, and any findings by the court. Whether an order should be made that would be least likely to lead to any further proceedings in the future, and any other fact or circumstance that the court thinks is relevant. So obviously that's quite broad. The court can consider anything they want that could be relevant. In relation to the second point, at least, whether an order should be made, that would be least likely to lead to further proceedings. Parenting orders are final in the sense that it's quite difficult to bring them back to the court. There are certain rules about the circumstances in which you can revisit that. Obviously, if you have existing parenting orders and you're wanting to revisit it, or you think these won't be long term, it's definitely worth getting advice in relation to that. But it is a court's intention that any parenting orders that are made on a final basis would continue until the child were 18. So they do take that into consideration about the practicality long term of orders. So especially if your child is quite young, it's a lot to consider in terms of, primary school, high school, what things will look like in 10 or more years. Obviously, things can be amended by agreement, but if there is a high conflict relationship, it is difficult to kind of have orders in place that look that far into the future. So again, worth getting advice on if you have concerns about that. So the golden question is, what age does a child need to be to decide where they live? Unfortunately, there's no magic answer to this. There's no set age in legislation. There's no magic number or anything, obviously until they're 18, in which case they wouldn't be considered a child. But there are lots of considerations, and the court does take their wishes into consideration in specific circumstances. So how do children's wishes fit into the legislative framework? The Convention on the Rights of a Child set this out, but basically, in short, if a child can articulate and express their views, it should be considered in the appropriate way or in a manner consistent with the procedural rules. Obviously, the family court has a structure for this. There are certain ways in which a child's views can be considered and certain weight put onto that. I will go through that now. So how are children's wishes captured in the family court? So there's 5 main ways. The last 2 of these are the most common. The first 3, just quickly, are by affidavit evidence of a parent or other witness at the commencement of legal proceedings. So for example, you put in your affidavit as a parent that, my child says this, that would be considered by a court. It could be from an auntie or a professional, somebody that deposes an affidavit in relation to your proceedings. That is one way the court can consider the child's wishes. It's possible for the judge to speak directly to children, and it is possible, although rare, for a child to seek to become a party to the proceedings. So the 2 most common ways that children's wishes are captured in the family court is by an ICL, so an independent children's lawyer, speaking directly to the child, and also by a family report being conducted. So what is an ICL? An independent children's lawyer is a solicitor who practices family law, and they're appointed by the court and are approved to be practicing as an ICL. They are on a list in legal aid who they're approved and apply for that. So their job is to work to ensure that any views expressed by the child are fully reported to the court in an admissible form. So that would be an affidavit, a family report, something that the judge can consider in the proceedings. It is an ICL's job to act in the best interest of the child, but not necessarily act on their wishes. So obviously, unless they're consistent. So if a child's wishes are one thing, but the ICL considers that their best interest is another, their best interests are going to prevail. But obviously, they will take into consideration their wishes, and they are also able, an ICL is also able to interact with professionals treating the child and the school they attend to kind of gather additional information that might otherwise not be available to the court, so that they can have that kind of holistic view of what is in their best interests. So family report is the other way that you can have the child's wishes considered in proceedings. So family reports can be obtained at various different stages of a matter, and it's not uncommon to obtain multiple family reports depending on how long your matter goes for, if it's in court for quite a while. You can obtain a family report without even going to court, and that's the first option there, which is private or pre-court family report. So there's numerous report writers. They're largely psychologists or social workers, people experienced with children and separation. So you can engage these report writers to produce a report without being in family law proceedings. And the way the process for this works is that they would meet with the parents and conduct interviews. Depending on the children's ages, they would also either interview the children directly, or they would observe the children with each of the parents during a changeover, just generally. So it depends on the children's ages, kind of what extent the family report writer will interact with them, kind of if they're interviewing them or just observing. But they would then produce a report about what they consider to be the time arrangements or care arrangements for the child that are in their best interests. So family reports can be ordered by the court. It's quite common for parenting matters to obtain these to provide insight in relation to the dynamic and the child's wishes. So that can happen kind of at various stages. Like I said, you can get multiple in proceedings. A family consultant can also produce a short report, which is called a child's impact report. So it might be that if early on in your proceedings, the court just wants a snapshot of extra information, a child's impact report can be obtained. So it's much, much shorter. It's just a couple of pages long, whereas a family report could be 20+ pages. And it's also possible for an ICL to order a family report. So you can find family report writers just by searching them or obtaining a recommendation from a firm and things like that. But, you know, it does provide insight in relation to the child's wishes and observations from a third-party professional. So what weight is applied to a child's wishes? It really does depend on a number of things, which are all on the slide. But when a judge or an ICL or even a family consultant is considering things that a child has articulated as their wishes, they're looking at things such as the child's age, their emotional and intellectual maturity, the strength of their wishes, if they're you know, super strong and articulate in their position, or if they're, you know, it could be this or could be that. Do their wishes have a sound and rational base, especially if they're being influenced? If it seems like a child has been coached, you know, if they're saying exactly words that their parents are saying, or just repeating things that they've heard or that a parent has told them, that's obviously of concern. You don't necessarily know that's their independent thought. Again, that would depend on their age and whether they're just repeating something they've heard or been told to repeat. And obviously, the court will also consider the impact this will have on the child if their wishes are followed or not followed. So obviously, the child wants to hear heard. It would be very difficult for a child to say, I want this, and then have everyone, including the family law system, completely disregard that. But equally, you have to weigh that against the long-term considerations and impact that would have on relationships and things like that. So moving on to the court process, I've previously discussed the second point there, which is the pre-action procedures. So prior to filing, unless urgent. So obviously I've talked about pre-action procedures and all these things you need to do prior to filing with the court. If your matter is urgent or you fit in a specific number of exceptions, family violence, domestic violence being one of those, you don't necessarily have to apply, you don't have to follow the pre-action procedures. You can, have an exception or just apply without doing that, obviously for your safety or just due to the urgency of your matter. But you do need to otherwise attempt to resolve the issue through family dispute resolution, obtaining a certificate, identifying those issues and the other things discussed. But in terms of commencing the court process, one parent would file an initiating application along with an affidavit and other supporting documents. So depending on whether it's a parenting matter or a financial matter, you would answer a questionnaire, potentially a financial statement, and then also a genuine steps certificate, which highlights, what pre-action procedures you have complied with, and if not, why. Once that's been filed, it gets served upon the other party. And then the other parent would then file a response outlining what their evidence is, completing the similar documentation. So the response, their affidavit, any other questionnaire or potentially a financial statement. And then it's worth highlighting that most matters that commence in court resolve at some point along the court process, whether that's through direct negotiations or mediation. So even if you have attended mediation, it is not uncommon for you to be sent off again. The court can send you to court-ordered mediation, which is kind of run through the court like a family dispute resolution, where the registrar, so a registrar of the court, would actually run the mediation. They can also send you off to attend private mediation again. In property matters, you in property matters, you could be sent off to a conciliation conference in relation to your property dispute, and various other things. But, once you've commenced court proceedings, there's an ongoing obligation to file cost notices. So you have to be upfront with the other party about the costs you're incurring in proceeding with your application, and vice versa with the respondent. And having that transparency in relation to costs and ongoing costs can often motivate parents and ex-spouses to settle matters. In terms of actually filing with the court, the judge will make orders to assist the parties to progress the matter. So once you file, you're not immediately in front of a judge discussing kind of the outcome of your case. The first step is very administrative. The registrar, the the registrar is going to look at your matter and kind of want to work out what needs to be done to progress it. So in property matters, it's obtaining valuation, finalising property pools. In parenting matters, it's obtaining those reports, making sure there's sufficient evidence before the court in relation to what's in a child's best interests and things like that. And as I previously said, you know, if often parties will be ordered to participate in a child impact report, and if it does proceed and they need further information, the court would then obtain a family report. So that's really informative for parenting and children matters. So yeah, depending on the age of the child, the family report is an opportunity for the child to express their wishes to the court, and for the court to have, I guess, a fuller picture of observations as well as first-hand evidence from both parents in relation to the children. So finally, you have reached an agreement, or you have reached temporary agreement in relation to the care arrangements for your children. There's a number of ways that can be documented. So you have informal, a parenting plan, or consent orders. Informal is exactly that. They're very flexible, not at all documented, although may lack some certainty. So parenting plans are more common in that they are documented. Similar level of flexibility in that they aren't enforceable, they're not filed with the court. They are easily amended because they are by agreement, and they can be a good way to have a first, I guess, plan or document for your child's care arrangements, especially if you've newly separated or if your child is quite young, because as I previously stated earlier, if you do have final court orders, the intention for those is that they are going to be long-term. So changing court orders, although it can be done by consent, is a lot more difficult than obviously changing a parenting plan, which is just a document which is more or less just to cement what you've agreed in writing, rather than having an informal agreement, which could be, oh, you said this and you said that, and no, you agreed, and it's a bit more difficult because you don't have that piece of paper to reference for your agreement. Yes, as I said, consent orders are enforceable and binding in the court. There is a little note there that says a consent order that has been made by a judge has the same enforceability as an order made in court by a judge. And sorry, what that means is if you agree to an order, whether that's at the foot of the court or during negotiations, and you file it with the court or you submit it to the judge and say, look, we've agreed on this, can you please make these orders? It is the same as if you stood in front of a judge, gave evidence, were cross-examined, etc., and the judge handed down a decision. They have the same enforceability. So whether or not you reach the decision together, or the judge made it for you, it's the same enforceability. So just quickly in relation to consent orders, there is an application form that you need to submit with your consent orders, which is available on the court website, and you also need to submit the terms of the agreement. So obviously a great time to engage a lawyer would be drafting those, so they are formal. Obviously it's not uncommon for parties to reach an agreement and then argue about how it's documented, or the specific wording, or how to enforce a term of an agreement. It might be that your intention was one thing, but the drafting of the document isn't necessarily sufficiently clear or articulate in relation to that. So it then becomes another point of argument. But when you are submitting consent orders, it is a great idea to have a lawyer either look over them or draft them for you prior to submitting them to court. So they are submitted to the court for approval. A registrar will consider those. And if there's any issues, they will write back and say, you know, this isn't approved for whatever reason. But more often than not, they just approve them, and then they are legally binding and enforceable. And a sealed copy of the order is uploaded to the court portal for you to download. I'm just going to quickly touch on domestic violence, obviously quite relevant to the family violence aspect of parenting proceedings. So as it says there, the Queensland's 20-year-old legislation was rewritten in 2012, some 10 years ago now, with many changes, including a broader definition of domestic violence. I believe that's again recently changed in relation to coercive control being more specifically defined as well. But in terms of obtaining a domestic violence order, there are 3 main steps or 3 main elements to prove. Those are that there is a relevant relationship. So if this is in relation to your ex-partner or the parent of your child, that relevant relationship is very easy to prove. It's quite well established. The second is that there's been an act of domestic violence. So there's a number of types of domestic violence on the screen. There's physical, sexual abuse, emotional, psychological abuse, economic abuse, or financial control, threats or coercive control or behaviour. There has to be an act of domestic violence. And the third step is that it is necessary and desirable to obtain an order. So there is no actual definition of what is necessary and desirable. There is case law in relation to this, but obviously if you have concerns about domestic violence or you think you might need a domestic violence order, protection order, strongly recommend that you obtain legal advice in relation to that. There's a lot of free services you can also call if you need assistance in relation to that. Quickly, in relation to some more changes since May 2017, previously domestic violence orders were only for 2 years and they're now being made for 5 years. The court must consider additional conditions now. They have the power to hear cross applications together. The court would consider any existing family law order and whether that needs to be varied or suspended if inconsistent with the need to protect a victim. So not overly common, but they do have the power to do that. And the court is also required to consider an ouster condition in all DV applications. So an ouster condition would require one party to vacate a residential property. So if you were sharing a residence, you have primary care of your children, and there is domestic violence, but you have nowhere else to go, the court can consider as a part of your domestic violence order that your ex-spouse be, I guess, evicted from the property so that you can remain there, and obviously they can't then come back and commit acts of domestic violence. Okay, moving on to property matters. These are the 3 main points I'm going to talk about. So there are certain circumstances which you must be in or a part of to have a property order made. In terms of the actual property order themselves, it's a 4-step process to divide the matrimonial assets and liabilities. And then there is also a time limitation in relation to how long you have to make these applications or reach these settlements. So the circumstances in which the court will make an order for alteration of property interests if the parties are married or in a de facto relationship for 2 years, or if there is a child of the de facto relationship. Other things the court will consider when making an order for an alteration of property interests are whether or not there's an existence of a prenuptial agreement. So if you have a binding financial agreement which was made prior to your marriage or relationship, that would be considered. Obviously, if you jointly hold asset or you have made substantial contributions to the relationship despite not having been in that de facto relationship for 2 years, you may still be able to have an alteration of those property interests ordered. So, 4-step process. I'm actually going to touch on each of these 4 steps in the next 4 slides, but just quickly, the first one is to identify and value all of the assets, liabilities, and superannuation. So basically, you need to establish the property pool. You need to know what is available for division. You need to assess the parties' contributions. So that's a matter of working out what contributions have been made and therefore who would get what from the division. Assessing future needs, which would be looking forward, what do parties need in light of what they're getting and what contributions have been made, and then finally, whether or not that is just and equitable. So in terms of identifying and valuing the assets, liabilities, and superannuation, property is quite broad. We're not talking just about your house and your car. So your property in relation to a matrimonial property pool will include real property. It will include motor vehicles, boats, jet skis, motorbikes, the money you have in a bank, your shares, if you're in a company, a business, furniture, your antiques, your artwork, frequent flyer points. Honestly, the list goes on. It is quite broad, but it is an accounting exercise of everything you own jointly and as a couple. So anything kind of in your own name, including overseas assets, would be brought into the matrimonial pool. What kind of weight they're given in terms of contributions is the next step, but in terms of actually identifying the pool, it all needs to go in there. Superannuation is included. There's different approaches on state by state, and you know, some people like to exclude it, and that can be something done by agreement, but for the court purpose, superannuation is included in your property pool. If any values are not agreed upon, they need to be valued by an expert. So in terms of valuation of real property, obviously there's different ways a house can be valued. You can have a real estate agent get an appraisal. You can have a bank value it for the purposes of your mortgage or your loan. For family law purposes, it's a third separate way. So that would be to have a property valuer, jointly appointed ordinarily, come and value the property. If you are able to both agree that the real estate appraisal or the bank valuation is the agreed amount or the value of the house you want to put on it, then that's totally fine. But in circumstances where it's not agreed, for example, bank valuations are usually conservative for the purposes of insurance or mortgages, and real estate value appraisals are usually high for the purposes of, you know, trying to obtain a sale or a client. It's often that they aren't agreed upon, and you know that the property valuer, which for family law purposes kind of comes in the middle, that is what we would use for family law purposes if it cannot be agreed. If you can agree on the value of the property, great. The only little tip I have in relation to identifying your assets is the value of the furniture or the things you own in your house is not what you insure them for, at least for family law purposes. For the purposes of obtaining your property pool, the value that you put on your furniture or your chattels and the things within your property are what they would sell at a garage sale tomorrow. So do not say, you know, $100,000 of my house contents when, you know, if you were to have a garage sale tomorrow, it's more likely 10 or 20,000. Righty, contributions. There's 3 stages at which you consider contributions in a relationship. So the first stage is at the commencement of the relationship. That's what the parties brought into the relationship. Were they on equal footing? Did one party bring in substantial contributions, such as, you know, they came in with a house, or they came in with incredible savings that were used to buy something that the parties now have, or something like that. But yeah, it's what you had at the commencement of your relationship, including your super, if you had super, and yeah, money in the bank, what you owned when you commenced cohabitation with your partner. Contributions during the relationship would be anything from when you commenced cohabitation until you separated. For this purpose, the length of the relationship is relevant. Contributions made during a 20-year relationship might not have the same weight as some contributions made during a 2-year relationship. And yes, the length of your relationship will be considered in relation to that. And then post-separation, any contributions you've made since the date of separation in relation to property, whether that's maintaining a mortgage or just conserving property here and there. In terms of what contributions are actually considered, 4 are listed at the bottom of the slide. So financial contributions, your big ticket items there are inheritance, redundancy, like lotto winnings, but big income, big amounts of money that come into the relationship. Your income is relevant to an extent. Obviously, if one party earns 80,000 and the other party earns 100,000, and you both work full time for the entirety of your relationship, the court isn't going to say, well, you've earned 20 grand more a year throughout. It's just viewed that you both worked full time. Non-financial contributions. So obviously you can see parenting and homemaking are there as separate points. So non-financial contributions refers more to things like renovations or restoration of property, basically improving the value of property from a non-financial contribution. Yeah, but that's more commonly things like a tradesperson completing improvements to property, or, you know, restoring a car from scratch, or things like that have significantly increased property without any financial input, but rather by the skill of the party. Parenting contributions obviously refer to the contributions made to family, and homemaking contributions are in relation to, you know, cooking, cleaning, maintaining the home, maintaining the yard, and things like that. So future need factors consider post-separation kind of going forward, and what needs to be considered in the division of the assets. So things such as your age, your health, your income and earning capacity is a big one. For example, if a party is earning $500,000 a year and the other party is earning $50,000 a year, it's more likely that the party earning less should get an adjustment in their favor, because the party earning a lot would be able to recoup that money very quickly, hypothetically through 1 year of work, and obviously the care of children of the relationship. Finally, once you consider all the contributions, future need factors, generally there is a percentage assigned to the pool. For example, one party gets 60%, one party gets 40%. The court then decides whether the outcome is just and equitable, and they're not just looking at the percentage division, they're looking at what the parties are receiving. So if one party is receiving only superannuation and one party is receiving, for example, a house and cash, they're going to look at whether or not that's fair for the party who doesn't have access to any of the assets that they're receiving for a significant period of time, depending on their age. But if it were that the party earning $500,000, for example, got the superannuation, it might be that, you know, they can recoup the money, and the party not earning a lot needs the house and the cash because they don't have a high income. So, you know, they consider the position of the parties and what the outcome of the division of the settlement is, and whether or not that is just and equitable. Obviously, it's very specific to your circumstances, and we'd advise getting advice in relation to that. Just in relation to the limitation, so in terms of obtaining a property settlement, if you're married, you can do it at any time after separation, but once you're simply divorced, there's a time limitation from the date your divorce comes into effect. So for 12 months post your divorce coming into effect, you can still apply, but once those 12 months is up, your time limitation essentially is up. And similarly for de facto, 2 years from your date of separation, once those 2 years has passed, you are essentially outside the time limitation. Although you have these time frames to apply to the court, if for whatever reason you need to apply outside of the time frame, you still can. You would need to seek leave to apply outside of these time frames, which means it's an additional hurdle to jump. You would have to apply to the court to get that leave. Then after you have the leave approved, you'd then make the application. So that would be addressing why you should be able to make it and why you haven't previously done it within the time frame. The court considers your circumstances, things such as whether you own joint property, as previously mentioned, whether you've made substantial contributions. Those are the things they consider in making those orders if you are outside of the time. And finally, how to document a property settlement. So consent orders or binding financial agreement are the two ways to document your property settlement. It's really important to get this done formally, if not only for the fact that if you have your property orders documented in one of these two ways, you can have things such as your stamp duty exempt for the transfer of a property. So it's really important to make sure it's kind of final, draw a line in the sand with a documented agreement. So consent orders I've previously touched on for parenting, so you can do them for parenting or financial, or you can do them all in once if you don't want to do the filing fee twice. So consent orders can be completed without lawyers. Like I said previously, the application form is available on the court website. However, in terms of drafting the orders themselves, the application form is one document, the orders are another. It would be very helpful to have legal advice on the orders that you draft, purely so they are enforceable. So those are submitted to the court. There is a $180 filing fee, and then it is sealed by the court, and they're enforceable and binding. A BFA is a private financial agreement. Both parties require independent legal advice in relation to this. So this doesn't have the same approval by the court and therefore does not need to be just and equitable in the eyes of the court. So it is an option if you're reaching an agreement that is kind of maybe outside of what the court would consider just and equitable. But for that reason, you have to have independent legal advice. That means the lawyers have to consider the document, provide you with written legal advice, and then sign off on that. And it must comply with strict technical requirements. So the Family Law Act has various sections that set out what needs to be in a binding financial agreement. As I said previously, unfortunately, I don't have the ability to read or answer your questions, but please, if you have any, feel free to send them to the email on the screen. There's also a feedback survey. And if you're looking for specific advice in relation to your circumstances, please reach out to a family lawyer. On the next page, there's also information about our fixed fee initial consultations. Thank you so much for your time.